Hello and welcome to the question paper analysis of Economic, Commercial and Intellectual Property Laws of the June 2025 exam. You've just written the exam today. So here we are bringing you the quick analysis of the question paper. We will be solving the question paper sometime later. So what is the overview or analysis of this question paper? It is an appropriate mix of direct questions and practical oriented questions, where in part A they are focused on direct theory questions. More of to the point questions have been asked. They have not even tried to include a case study to that question. So it is more of direct theory questions, whereas under part B, majority of the questions are practical oriented, where they are checking your applicability of interpretation skills. How are you going to interpret the provision of law and apply in a given scenario, in a given situations? So it is more of thinking, interpretation and analytical questions that have been asked in part B of the syllabus. As teachers, we generally say that concentrate on part B of the syllabus. It is for 40 marks, hardly 6 chapters to study. It is less vast as in comparison to part A of the syllabus. That is why the institute has taken that part as a little bit challenging and given difficult questions in terms of that it is not direct. They have not asked any direct question. They have only given you the case study, and even the sub questions that have been asked are in relation to the case study. Generally, I tell that read the sub questions first. You will be able to answer those questions even without reading the case study. But this time the institute has not done that. Without reading the case study, without seeing the facts of that case, it is not possible to answer the sub questions that have been asked. So yes, slightly for students it might be difficult for interpreting and giving a conclusion of whether it is possible or not possible. So if you are very well prepared, you can answer, but otherwise slightly I say the level of difficulty for part B is higher in comparison to the previous attempt. Moderate difficulty level, it is a mix of easy and difficult questions. Part A is easier in comparison to part B. It is a moderate paper overall. Testing both knowledge and legal reasoning skills. So they are testing your knowledge. They want to see whether you have conceptual clarity. They want to see whether you know the law of the country. In addition to that, they want to test whether you are able to give a reason to a particular law. In a given situation, how are you going to get your client out of that legal situation that he is come in? How are you going to advise your client? How are we going to apply the law in a given facts of the case? That level of expectation the institute is having with respect to this paper. It is a mix of factual, conceptual and analytical questions, where they are testing your interpretational skills along with applicability of a law. They are not testing your memory at all. Here they are more focused on do you understand the law, do you understand the concept, if you do, how are you going to apply it in a given scenario. That level of testing is there in this particular question paper. Lastly, appropriate weightage of marks. On an average, from every chapter they have asked for 5 marks. In part A and part B, one chapters they have selected from which they have asked for 15 marks. Otherwise, from all other chapters, on an average 5 marks is being asked. So that is why we say please study the entire syllabus if you want to answer for 100 marks. Let's look at the weightage. Like I told you, it's an average of 5 from every chapter. From every chapter, they have asked for 5 marks. Only from fugitive economic offenders, they have not asked anything. And with respect to Consumer Protection Act, they have asked 15 marks. All other chapters is 5 marks. So importance of predominance is given to Consumer Protection Act, where 15 marks is asked. That is the first case study type of question, where all sub questions are from the Consumer Protection Act itself. That one question carries 15 marks. All other chapters are for 5 marks itself. Going to part B of the syllabus, importance has been given to the Patent Act, which is 20 marks, Trademark Act, which is for 15 marks. All others are almost 5 marks each. GI they have asked for 10 marks. So like always, all the teachers say the same thing. Patent and trademarks are very, very important from the examination point of view and even from practical applicability of point of view, because many of the businesses are focused on these 2 aspects. So these are the important chapters. Rightly weightage is given 20 and 15. All other chapters are 5 marks. At GI this time they have asked for 10 marks because they have asked a case study type of question from that particular chapter. With this basic breakdown of weightage, let's directly look into the question paper that has been asked by the institute today. So the first question is a case study based question from part A, which belongs to the Consumer Protection Act. They say that there was a company which was manufacturing herbal and Ayurvedic products, and they had given an advertisement claiming a lot of medical benefits and properties, and which had no scientific evidence, but still they promoted that it has been proved. On the basis of the advertisements, one of the consumer, Mr. Rajiv, had purchased those products. Ultimately, he did not find any benefit out of it, so he's filed a complaint against an organization for giving false and misleading advertisement, and he's filed the complaint before a Secretary, Ministry of Health, Government of India. That advertisement is misleading and false. So, even the Advertising Standard Council of India held that it is a misleading advertisement, but the company was not happy, so they preferred a appeal before the Supreme Court under 136 of the Constitution, requesting special leave petition. They have asked you to, so that part of the question is not relevant for us, where they have filed the appeal, Supreme Court 136, all that is as of now not relevant for us. They have just given a conclusive end to the question. The ultimate question is 15 marks from Consumer Protection Act, where first one is a direct question. They want you to tell who is a consumer and can Rajiv be classified as a consumer or not. So here the same sub question carries a theory question of who is a consumer and the applicability, whether Rajiv in this given scenario will come under the ambit of consumer or not. Second, whether false, misleading and deceptive advertisements can be treated as unfair trade practice. If yes, explain in detail. So you have to tell what is unfair trade practice as per the provisions of Consumer Protection Act, and whether in this given scenario, this false, misleading advertisement that they have been giving with respect to Ayurvedic products, whether it classifies as unfair trade practice or not. Can the producer and directors be punished, penalized for issuing false and misleading advertisements under the Consumer Protection Act? So we know for misleading advertisement, it is not only the Consumer Protection Act that is applicable, but we have other regulations and rules as well. So they want you to specifically tell whether under Consumer Protection Act there is any penalty provision that can be imposed on the directors in the company which is issuing misleading advertisement. So as of now, whatever we have seen is theory based questions itself, not lot of practical applicability. Next, when and to whom a case may be lodged against and appealed against such order. So they're just asking the jurisdiction where you're going to file the case, where you're going to appeal, which court has the jurisdiction, that is what they are checking. Next, distinguish between defect and deficiency under the Consumer Protection Act. Defect in a product, deficiency in service. So the difference between the two concepts they are asking. So if you see, all the 15 marks from the Consumer Protection Act is majorly direct. Hardly 2 mark applicability was there, whether Rajiv can be considered as consumer or not. All other questions are direct theory questions. Next, second question is based on overseas direct investment, where they are asking you, firstly, they have given a situation that there is a trust, educational trust, which was registered in December 2023. In February 2025, they have made an application to RBI asking approval for investing in US dollars in a foreign entity. So they want to see whether this particular trust is eligible for making the investment in the foreign entity or not. Duration plays a significant role. They want you to give reasons for your answer, whether this investment is permissible or not permissible. In addition to that, they want you to give the conditions that should be satisfied by an organization before making an overseas direct investment. So they've given you applicability of a case study, plus they've asked you theory question also, what are the conditions. Next question is liberalized remittance scheme. Generally this question is there. So they've just given situations, 5 situations, and asked whether prior approval is required or not before executing these transactions. So 5 different transactions have been given. You should tell yes or no whether prior approval is required or prior approval is not required for executing these transactions under the liberalized remittance scheme. Next question is, the Exim Bank wants to receive foreign direct investment, and they also through that mechanism want to raise funds for the purpose of trading activities from Japan. They want you to give what is the procedure for raising external commercial borrowing. So they've given you the facts, but ultimately it is a direct question where they're asking you what is the procedure of raising ECB. That is what they're asking you in this particular question. Next. Again, a direct question. They've given you the facts that one company is there. It is engaged in construction, airport development, air transport services, etc. So civil aviation sector they belong to. They want to make an investment in that particular sector. So they want you to tell what is the permissible limit of direct entry route for that particular sector through FDI mechanism. What is the permissible limit to receive such investment as per this? So explain the entry route for investment as well as the permissible limit. So both you have to give. Next. X was caught transferring funds from illegal exports of opium from India to South Africa. State whether X has committed any kind of offence under the Prevention of Money Laundering Act. What is the punishment that can be imposed on X? So direct question they are asking. They've given a situation, one practical approach is, does that offence classify as an offence under the Prevention of Money Laundering Act? If it does, what is the punishment that can be given for this offence that has been committed? So slightly yes, applicability of mind is required for this particular question. Next, a housing project was launched in 2015, which is still ongoing. The RERA Act came into existence in 2016, so the project was not registered, but now because it is still an ongoing project, the company wants to register this one particular project under RERA provisions. They are asking whether a project that was started before RERA came into existence but is still ongoing, can those category of projects also be registered under RERA provisions? And they want you to also answer what are the projects that are exempt from RERA registration. So I think it is a direct question. With respect to transitionary provisions and with respect to exemption provisions. Again, a direct question. Next. What are the objectives of OIML certification under Legal Metrology Act? Direct question. State the factors that the CCI has to take into consideration while considering whether a particular combination is going to have appreciable adverse effect on the competition in India or not. Again, direct question. What is the manner what manner is the Special Economic Authority constituted, constitution of the authority, and what are the functions of these authority under the SEZ Act? Direct question. No case study, nothing, direct theory question. If you have prepared those chapters well, you should be able to write. Next, explain the provision relating to special codes under the Benami Transaction Act, section 50. They have provided the section number also to you. So it is a direct question. Again, all these questions are direct. Under what circumstances central government is permitted to cancel the license or certificate which is granted under section 12 for receiving foreign contribution under the FCRA provisions? Direct theory question. State the objectives of National Committee on Trade Facilitation and how the action plan will achieve the objective that has been laid down. Direct question from the Foreign Trade Policy of 2023. This is there in the amendment material. So direct theory questions. Last few questions are direct theory questions. So overall in part A, out of 60 marks, majority are direct questions. Only hardly 5 or 10 marks is where you have to apply your provision of law with the given case study and given interpretation. All other questions are direct questions. Moving to part B, which is more challenging than part A. First one, it is a question on patent. They have said that this one particular company is a pharmaceutical company and it has filed an application for a drug saying that it is helping in cancer treatment, and it is one particular drug that is called as beta crystalline, and they say that it is an improved version of some other drug. Okay, it's already known before, but it is an improved version with more efficiency is what they are claiming. But the patent application in India was rejected, saying that it has nothing to do, it does not meet the criteria of patentability because it is not new, it is just an improvisation of already existing material. So they rejected the application under section 3 subsection D, which says that it prohibits patenting until and unless it has some kind of efficiency compared to original compound. The decision was challenged before the appellate board. Even appellate board rejected the application, saying that it is not new, so we are not going to give you any kind of registration. They have preferred an appeal before Supreme Court, and they are asking two questions: already known substance, whether it is patentable or not, and whether the restriction that they have imposed under section 3 subsection D, does it satisfy or does it match the international standards, or is it too restrictive in India that we are not giving registrations for an improvised version of an existing product. So is it too strict, and whether it is patentable to just patent a already existing product's improved version. These are the questions that were asked in the Supreme Court. On the basis of this case, they are asking you certain questions. First few questions are direct questions. What is meant by patent and what can be patentable? Easy theory question. When mere discovery of a new form of substance will not be treated as a new invention under section 3 subsection B. It is a theory question, but you have to give an explanation for the provision of 3D, which is an application of mind. Okay. Next, what are the rights of the patentee? Again, it is a direct theory question from the Patent Act. Now, what comes later is the applicability of your mind, where you have to do interpretation. Are patentability criteria under 3D according to the international standards or not? And last question is, will the pharmaceutical company in this particular case succeed according to the Patent Act or not? You should tell whether the patent will be granted or will not be granted in the given scenario, that it is just an improvised version of an existing compound which they claim to be more efficient. Under 3D, should it be rejected or should the patent be granted or not? What is your outcome? What do you think you have to give in that situation? So this is the most challenging question because you have to give legal reasoning. Okay. Next, second question is on the basis of geographical indication. They say that this Kanchipuram silk is from Tamil Nadu. A particular cooperative society, Kanchipuram Handloom Silk Weavers Cooperative Society, had made an application for GI, and the GI is registered in the name of this cooperative society. Generally, I say the GI is not registered in one person's name. It is a collective registration that is given to a particular group of people who are experts in that particular handicraft or that particular delicacy, whatever. A particular group of people from a region will be given the right to use the GI. So this particular group, cooperative society, had made an application in the name of Kanchipuram sarees, and they got the GI. Now some other members from other area have made an application for similar GI which was being granted. That has been challenged by this cooperative society, saying that we are the ones who have started this, it is a unique product, we are the only people who are belonging to this cooperative society should be permitted to use the GI and nobody else should be allowed. So the expansion of ambit for use of GI should not be given. We want to maintain the uniqueness and quality of the product. If you allow people, other weavers, other producers to manufacture the same product, it will lose its originality, it will lose the uniqueness, it will lose the quality. So don't permit anybody else. They want to issue a temporary injunction and cancel the GI usage to the other group of other producers or other weavers outside the ambit of this cooperative society, saying that it will result in misuse and exploitation of GI. So this is the facts of the case, and they are saying that exclusive right should be given only to the producers from the Kanchipuram region to protect the authenticity of the project, and it would lead to exploitation. Union of India has responded saying that the entire purpose of giving geographical protection to a product is to give protection to the product and not restrict the registration based on the type of producers. We are protecting the product, but we are not telling that it should be restricted to a particular group of producers. That is the contention of the Union of India, that is the government who has granted the GI registration. On the basis of these facts, first question is basic. What is meant by GI? Theory question. What are the benefits of getting a GI registration? Theory question. What is the difference between GI and trademark? Like always, repeated question is a theory question. What is coming here, next two questions are the practical oriented questions, where when may a registered GI be treated as infringed? Theory question. Is the contention of Union of India, the respondent, correct? Explain. What the government is saying, that we are giving protection to the product but we are not restricting the producers. Is that contention of the government valid or not valid according to you? You have to give that outcome. So in both these case study type of questions, first four questions have been theory questions and the last one is interpretation question, where you have to apply your mind. Coming to the next question. Rajat is a proprietor. He has filed an application for patent of a smartwatch which he claims to be a new invention, but the design of his product is already similar to a existing product. So they want you to tell in this given scenario how the controller will issue any kind of direction to Rajat under section 19 of the Patents Act. Okay, that is what they are saying. No, so I combined two questions, sorry. So the 6A says that it was a patent for smartwatch which was a new invention, but the invention cannot be performed without a risk of infringement of another patent which was already existing. In this case, what is the direction that the controller of patent is going to give to Mr. Rajat under section 19 of the Patent Act is what is being questioned. Next question is on the basis of design, that they have designed a new device which incorporates a cell phone and internet capabilities. The device is very similar to the already existing device of any other company, that is the competitor. What are the requirements that a person should satisfy for registration of a product as a design? That is what they are asking you. It is just requirement criteria for registration of design, again direct theory question. Next is based on trademark. But this is a case study based and application based question. ABC Limited was incorporated in 1996 and deals with plywood in the name of Uniply. But it came to be known in 1999. In 1999, that company got to know that XYZ is also using the name Uniply. ABCD has filed a case against XYZ Limited for infringement and temporary injunction that stop using the word Uniply because we are using it since 1996. The court has granted them the temporary injunction, and XYZ Limited has also filed an appeal against ABCD Limited, saying that it was incorporated in 1993 before ABC Limited was incorporated, and they have been carrying on the business in the name of Uniply since 1993. So they have prior usage. Maybe they have got the registration before, but they have prior usage because it was incorporated before 1996. So on the basis of this priority of usage, we should tell whether XYZ can be restrained from using the name Uniply with reference to case laws under Trademark Act. Next is, a pharmaceutical company develops a new drug with specific chemical compound carbon dioxide. The word carbon dioxide, can it be registered as trademark or not under the Trademark Act? You have to give a reply. Next, section 6A, which is alternative to question 6. When a license can be terminated under Copyright Act? What are the goals of the National Intellectual Property Right Policy? They have given the statement. You have to comment on the statement that has been provided. Who is trademark agent and state the qualification requirement for being registered as a trademark agent? How a patent specification is prepared? When an application for patent published? When is an application for patent published as per the Patent Act? So all questions under 6A are direct theory questions which are simple. So if you have an option between 6 and 6A, it is advisable to go for section 6A if you are well prepared. So overall, it is a moderately difficult paper. If you are prepared well, it should not be difficult, but it is slightly challenging in terms of applicability of provisions of law. With this, I will wind up the question paper analysis. Soon we will bring the solving of this particular question paper. Till then, you have one more paper to go. All the best and do well.